Good afternoon. Welcome to Cannabis Live. I'm Travis Copenhaver.
Nicholas Galendez.
Today we decided to do something a little different. We asked our staff here at Cannabis Legal Group to put together a list of what we would consider probably the most common questions we receive when people call our offices asking about cannabis licensing and cannabis topics. We're going to put them into a rough order. I don't know if this is technically the correct order or not, but we're going to go with it. So at number 5 here are most of our top 5 most common questions. Who has to submit application materials? Who's a supplemental applicant?
Right, and I think to preface this too, Travis and I have been in this for over 2 years in the medical MMFLA facility licensing process. And previously, before that, had done medical marijuana caregiver.
4 years, right?
Well, right. So we have right. So I'm saying, for 2 years or so, or more, a little bit now, the MMFLA application process has been online, and rules and application processes have been there. So this is what we're talking about. But even before that, we dealt with caregiver questions, with caregiver location questions, and after the MMFLA was implemented, we started getting questions about the new rules and the new application forms, and then they changed, and then there's emergency rules and new permanent administrative rules. And what I think we've seen is that this list actually hasn't changed very much.
It's true. It's the same questions over and over.
So really, but they're different because the target keeps changing and the rules and the language keep changing a little bit.
Sometimes the answers change.
So it kind of is worth going over these one more time just to make sure that everyone's on the same page, and we can kind of echo that to everyone who watches, and just make sure that everyone's getting the most accurate information from us on the front lines of everything.
Sure. So I'll ask again, our number 5 question.
Right.
Who has to submit the application materials?
Right. And in Michigan right now, a lot of the rules and regulations are tailored towards who owns it or who controls the company. And so really right now we have a more or less generally a 10% rule for who has to submit an application. So for those owners who have over 10%, so 10.1%, all the way up to 100%, those individuals or those entities have to, if they own more than 10% of the applicant company, submit a supplemental application with fingerprints, with background checks,
all the
3 years of tax returns, 12 months of bank statements, the whole shebang, be fingerprinted, get vetted, so on and so forth.
Now, and by way of example, it used to be 1%, so now it's 10%. But yes, that's our 10% rule. We've talked about it several times on the show. And whenever I like to tell people that are working with me, whenever we identify a human that needs to submit a background check, that person's spouse also needs to submit a background check.
Yeah, and they care about direct and indirect interests. So, for example, if I was an LLC, or if I created an LLC and wanted to apply and try to get myself, to prevent myself from having to do fingerprinting. So I thought, hey, maybe the bright idea would be, all right, so Nick Cannabis LLC is owned 100% by Nick Holdings LLC. Well, I'm the 100% owner of Nick Holdings, and they're the 100% owner of the applicant company. So I still, regardless of that little additional layer, I'm still the 100% indirect owner of the applicant company. So they crunch the numbers, and it's simple math, but you basically have to, anyone who has 10% or more direct or indirect has to actually submit fingerprints and actually be vetted through the full process. So there's no way around that. There's no way other than divorcing your spouse, which takes a while, which requires you to provide a judgment of divorce. You have to be, you have to submit an application. In addition to that, they kind of define managers as, as an LLC, somebody will be named as the manager, but it also kind of includes C-suite, executive, people who are director of operations,
basically corporate officers is the next one. So it's ownership and corporate officers. So depending on your corporate form, there's different types of corporate officers. A corporation, for example, has a board of directors. A LLC sometimes has an LLC manager. A nonprofit might have different positions, etc. If you are in the capacity as a corporate officer, you're going to be submitting a supplemental application regardless of your ownership. And just like with ownership, if you are the CEO of the company, then your spouse is going to be submitting a supplemental application as well.
And then I think finally, the MRA contains language, or the MMFLA contains language, as well as the MRTMA about managerial employees. And the definition of that is basically if you have policy-making authority or the ability to control the affairs of the facility.
Yep.
And right now, we know there's an FAQ. We know it's somewhat defined, and one of the things that we're going to be doing here at CLG at least is responding, asking the MRA to clarify that a little more, because right now the industry is moving very fast. A lot of applicants aren't sure who really would fit this definition. You have some applicants who are risk averse that are maybe adding too many people on there that don't need to be. And on the same vein, there might be some applicants who tend to try to, highly constrain that one person's ability to say, oh no, they're not a managerial employee, when maybe the regulators might say that they should be. So all we want is very, clear regulations to kind of make it, able to actually guide these people into what they actually want to have done based on their operations, so that no one's caught by surprise that they have to be vetted or should have been if they aren't. So
right. I mean, the simple rule of thumb we know for sure is if you're acting like a corporate officer, regardless if you have the title, then you're going to be considered a managerial employee. What Nick's trying to highlight is some of the gray areas. Like we know, for example, if I own a grow facility and I have someone whose job it is to be on site at that facility as the manager of that facility, that's not the type of managerial employee the MRA is talking about. We're talking about people with positions within the company that have the ability to set the company's decision making in a certain direction with the responsibility for the decisions of that company. So it's easy for us to think, well, that's a president, that's a CEO, something along those lines, but there might be people with positions of power in the company that don't have the titles to reflect that power, and sometimes the managerial employees might be determined after the fact. So there's simple answers, and then Nick highlighted some of the very gray areas as well.
Yeah, and I think what you'll see from all these questions is there's never one answer. It all depends on so many different factors, and
Sure.
really, and that's the key to it. There's really no one, price that this costs. There's no one specific be-all, end-all rule that's going to make it easy to fit in every situation. So
Sure. So let's move on to our next most common question. I want an adult use license. Do I need a medical license first?
yes, for most licenses except for two.
It's not. There's
Right.
there's exceptions. So
Sure.
so in most cases the answer is yes. Let's start with some exceptions first. There's two licenses specifically designed for Michigan residents that you can directly apply for. The first is the Class A adult use license, grower license. That's the 100 plant count license. The second is a micro business. That's the 150 plant count grow and retail all in one location with processing as well if you want to do it. Those two licenses are specifically for Michigan residents. You do not need a previous MMFLA license to pursue them. We also have the special licenses. The excise grower is kind of the exception. You by definition need other licenses for that. But the temporary events, the event organizer license, and the designated consumption licenses, you can be applied for directly as well without previous medical licensing. However, all the rest in the adult use system do need licenses. Which ones are those?
Well, and did you mention that testing labs on the adult use side don't need that either?
I did not.
Okay, so
Thank
so
you for
that's one
mentioning
of them. So it's Class A micro business, 100 plants, micro business that doesn't need it, as well as to test for adult use. You don't need to have one on the medical side. But
if
for
you're-
every other license,
So Class B, Class C, secure transportation, marijuana retailers, all of those adult use license types would require you to have at least one medical marijuana license. And that is, again, for the first 2 years of the adult use program. So after 2021, November 2021, I believe, or December?
2020, yeah, something like that.
It's 2019 to 2021. So eventually these licenses will be open. The licenses that are just for Michigan residents will be open to non-Michigan residents. The licenses that require you to have a medical license first will be available to companies without medical licenses.
Yeah, and I think here's the key, bringing it back into the gray area, is that, or at least to clarify for everyone, if I'm an individual that owns a company that has a medical license, that same company with that same ownership needs to be the one that applies for adult use. So I can't create a new company and say, oh, I'm applying for a retailer. It needs to be that same company that has a medical provisioning center license or a grow license or processor license that I then put through the adult use system and then apply for that license. So there's a difference between myself owning a company that's applying versus myself creating a different company. It has to match on both sides.
Very common mistake. If Nick is a supplemental applicant on a medical project and Nick wants to seek an adult use license, but he's doing that in a different corporate vehicle than he did with his medical license, too bad. Nick is a supplemental applicant. The applicant is the company itself. So let's move on to our next most common question. My municipality has opted out what do I do if I want to open a business there?
Yeah, there's a lot of different ways that you can do that. I think the first and most common one is to talk to your local officials, and I think we've kind of had a lot of other shows about this, but really without kind of a change in the board or the council, or getting them educated and realizing that this might be something that they can adopt to allow businesses to flourish and for jobs to be created there. You run for city council or for township board, you convince the already elected officials to do that, you vote for those who are coming on and opposing those who are already in place to kind of change the guard and get more pro-cannabis people who are running your city or town. Aside from that, there is the ability in certain cities, towns, and villages to do a ballot initiative where you can get enough signatures with appropriate language, get that on for the vote in that municipality, and have them at least opt in for that. They would get to control zoning language, so on and so forth.
Now there's in some cases you can do a ballot type procedure for medical. However, it's adult use that the state has created a ballot process. So, if you want to do a medical license, the ballot procedure may not be available to you. However, the state law, Proposal 1, Regulation and Taxation of Marijuana Act, does create a ballot process for all adult use municipalities.
So again, it depends. It depends on if you're a home rule city, if you're a general charter township, if you're a common township. There's a lot of different things that go into that. It depends on the language of the charter, what's available in the ordinance, whether or not your ordinance does too much by trying to create zoning restrictions as opposed to just opting in. So again, just like with the other two questions, it really depends, and that's why it's hard to provide one answer where there's so many different things that kind of get involved when you go down into the specifics.
I think the simple thing to remember for this question, though, is ordinances are not permanent. So if your community has passed an ordinance or a resolution opting out of either the medical or adult use program, the way they can allow cannabis licenses in the future is to pass a new ordinance, opting right back in. How do you convince a municipality to pass a new ordinance? Well, there's a great question. There's lots of ways to do it. It usually comes down to lobbying in some sort of form.
And I've found that lobbying, I think, gets some negative connotations sometimes, and it doesn't have to.
Yeah.
I really think that the grassroots approach works better, where if you've lived there forever and you know everyone in your town or city, and you've talked to them, and you go to meetings and talk to them about other things like roads and sidewalks and different millages and everything that really, you're not just there for cannabis, and they really can see that you're being genuine. That's always a good approach to get their ear about things. But obviously lobbying and kind of, which is a different way than the grassroots approach of them still getting to know you and feeling comfortable with you, other than you just kind of going in and throwing around your weight and trying to force them to do something, I think is always the better approach, because nobody likes something trying to be forced upon them. Even in a ballot initiative, then things can get strung out and can create more issues than if you were just to try the slower but steady grassroots way. So
exactly. So the next two are our top two most common questions. They're kind of a toss-up. So we'll start with what we have on our list in this order is, well, how much is it going to cost me to open a cannabis business?
Well, I think that on that end where, we're a business decision, we're a part of the cog. There's architects, engineers, contractors, marketing, CPAs, HR. There's so many different pieces of the puzzle that you or somebody that you're working with or your company needs to figure out. And so part of that is doing your due diligence and figuring out the numbers, figuring out what the market value is of the property where you might want to be purchasing or leasing. You want to figure out the price per pound. You want to figure out how much legal services cost, how much a knowledgeable architect and engineer are actually going to cost, and then really create that pro forma, figure out your expenses and your capital operating, throughout that year and beyond, because it all depends.
There are, over 15 different types of cannabis licenses for 15 different types of cannabis businesses. They're all very different from one another. 15 might not be it. I didn't actually count them. But you should, you don't have to make a formal business plan, but you should have a general idea of what kind of business you want to open. Well, I want to be a grower. Okay, how large of a grower? How many plants do I need to grow? What's my cultivation style? Do I know how to grow, or do I have to find someone who does? You don't need to go pay a professional to tell you how to run a business. You should think about why you want to run this business in the first place, and think about how the cost to get you there. In general, this is, in my experience, a very expensive procedure, and we're just a small piece of it, like Nick said. But it's not an unsurmountable amount for most groups of people with the resources to start a new business. I don't think anything about a cannabis business is inherently more expensive than a similar type of industry business would be, with the caveat that cannabis laws are complicated and constantly changing, and that certainly adds cost and risk. The ability for municipalities to really limit the people who can pursue these businesses create a lot of cost and risk, especially if you're in competitive situations. But when you assume that you need to pass a state background check, that's a pretty easy amount of work that you can estimate how much time it's going to cost you. You need to find a municipality that's going to allow you to open a business. Well, you got to find a location. You need to get the community's permission to operate the type of business you want. So that implies you need a location. It implies you need to get permission from a community through a business licensing process. And then when you have both of those things, you need to actually build your business. So, a cultivation facility is going to be likely more expensive to build out than a retail store, but a cultivation facility is going to be a lot less competitive to obtain. So, there really isn't a number we throw out, because, if you're in a position where you're lucky enough to already have a location, then that could be a huge amount of savings for you. If you have some sort of skill set where you don't have to pay someone to do it for you, it's going to be a huge amount of savings for you. But start to finish, it's certainly not something that the average person does by themselves, but you get a group of motivated people with funds to dedicate to the project, and it is certainly not just for the the one percenters of the world. You can do this with a reasonable amount of assets. Now, we know that a reasonable amount of assets quickly approaches funds in the $500,000 to $1 million range or more sometimes. Now, that's a lot of money for any one person, I'm sure, but it's not an impossible amount of money. What really makes the costs much more poignant in the cannabis space is lack of access to traditional banking services. You can't utilize a mechanism such as a mortgage to purchase property, because banks don't want to put a mortgage on location that is for known cannabis use. You can't get a business loan. Banks don't want to give a loan to a federally illegal project. So the numbers themselves don't strike me as exorbitantly high, but it does kind of create some barriers that a lot of groups aren't going to be able to pass unless they have either independent wealth or someone who's willing to be an investor in them that has access to independent wealth to spend on these projects.
And I think another thing to think about too, just to kind of piggyback off of what Travis said, was when you're looking for that local approval and you need to find that property, whether you're buying it or leasing it, obviously the market, if you are a property owner in a green zoned suitable location, you are within your right to demand more, because that is more in demand for that location. So you already know, regardless of what the municipality is going to set up as that process, you're going to be paying a pretty penny for that location, for that lease, so on and so forth. But really, the other things to kind of think about is, okay, am I going into a municipality that's kind of a check the box requirements where, okay, we submit a 2-page application, verify that the site is okay, give you some plans, and then you take it through your own review process, and then you give us a license? Is it a lottery where we kind of have to check the boxes and then kind of leave it up to chance? Maybe go a little bit more above and beyond than a check the box application, but it's still kind of, we don't have to put our full effort into it to try to win this. But then on the other hand, probably the most costly way of doing things that municipalities are doing, not only in Michigan but across the United States, is the competitive merit-based application process, similar to Pontiac, similar to Lansing, some other ones that are coming on board now that are kind of adopting that process, requires applicants to go so far above and beyond what the state would require you to do a license, and it's within their realm to do that, because cities and towns have control to create those rules and I don't want to call them hurdles, but just requirements in order for them to feel comfortable and vet you and give you approval to do that. And I think knowing that it's competitive, they want to select the best and do their due diligence to actually select them. So they make you spend time, money, effort, resources in providing these novels of applications to try to show them, like, hey, we want to be here, this is what we're providing, so on and so forth. And we've seen on our end, and I'm sure on both locally, within the state and nationwide, that those can be costly, just because many people want to be especially in big markets.
And usually you see different competition levels for different license types. I think we can all agree that the retail, be it a medical provisioning center, an adult use marijuana retailer, is the type of competition where you see the largest amount of interested parties for the smallest amount of slots. Like how many provisioning center applications did they get in Pontiac, Nick?
104.
104
For 20 spots, and they were separated by different districts, and one of them had almost half of them. So, you know, you're playing the percentages, you're wagering on the locations being, you know, scarce or.
So if you're competing against 100 other applicants for 20 slots and you're trying to win, you can easily see how you might be dedicating resources to be as competitive as possible. Whereas if you're a grow facility in a community with no caps, you know, you hit all the boxes you're supposed to hit, and as long as the municipality likes you and you do everything they ask of you, you're probably going to get your license for pennies on the dollar compared to a Pontiac
and it's
situation.
all relative. I mean, it's still a, you know, tall order compared to, you know, even out of our pockets. It's just it's a lot to liquid funds just to be putting down on, you know, purchase agreements, application fees, legal fees, architectural fees, so on and so forth. And then I guess the other thing to go along with that, what application type is, what am I doing? Like you mentioned, your grow methods, your processing methods. Am I just a kitchen, or am I buying a bunch of, you know, ethanol distillation chemistry material to actually do that, versus do I just need an oven and some baking sheets? You know, and that all depends, because especially, you know, when we get asked these questions, we're not really familiar with what you might want to do, and you might not know that either. So it's hard to say, well, it costs this much, because it probably won't, based on how many other different things we're not sure of, or you're not even sure of until they become to your attention. So
now, and then our most common question, and this might be partly because half our law firm's a criminal defense firm, but I have criminal history. Can I participate in the cannabis industry?
it depends.
It depends again. So how does it depend, Nick?
So the MMFLA and adult use law, the MRTMA, have two different kinds of sets of rules. For the medical side of things, there's a 10-year felony and then a 5-year controlled substance, theft, dishonesty, or fraud misdemeanor, complete mandatory bar. So if you fall within those 10 or 5-year rules, you are automatically ineligible for a license.
If you are an owner of the license, or a manager, employee, or a corporate officer of the license, but you can still be an employee of the license.
Correct. So yeah, it depends if you're an owner, if you're considered an applicant or supplemental applicant. If you're a regular employee, there's a 10-year requirement to not have a felony. Otherwise, you need permission from the MRA. So you can still be, if you have a felony within that time frame, get approval from the regulators to work as a normal employee for that facility.
There's a different limitation. If you're a driver for a secure transporter, you can't have certain types of misdemeanors in the last 5 years as an employee. So, you know, there's ways to participate. There's almost always a way you can participate. Unless your criminal history is relevant to providing providing cannabis to minors. There's a prohibition on the adult use side for being an employee if you have a criminal charge for providing cannabis to minors.
And that goes the same for on the adult use side, applicants who have a conviction, whether that be a felony or misdemeanor for distribution of controlled substances to a minor, that's a complete bar to being an owner or applicant or
But other criminal
employee.
history, it can be relevant, so that's something we should touch on as well. There are, you know, statutory prohibitions that the state doesn't have any gray area about. But then you could have some criminal history that would be in the merit-based bucket, where they can still deny you for any criminal history if it is a sign that you might contribute to this company's inability to follow the rules and regs. Nick probably knows the
right.
rules.
So on the MMFLA side, Section 4023
I figured
has the permissive grounds, the permissive grounds for denying people, which includes moral character, reputation, integrity, which kind of goes to the heart of, you know, your criminal history, your past litigation that might, you know, obviously in the business world, you're going to have you may have some run-ins with former business colleagues or other companies that end up, you know, involving you in litigation. But as we see the regulators kind of shifting, and this is, I think, a better example on the adult use side, the law and the rules specifically say we care about this as it pertains to you running a business, you know, how it actually goes to the heart of you running a business. So, you know, if you have some issues with law enforcement or run-ins in the past that don't necessarily go to any, you know, have anything to do, if they're not relevant or probative or really have anything to do with you having to run a business or doing that with, you know, with the public interest and good in mind. Or, you know, the same goes with litigation, where we don't, you know, there's a probate case here and there's a contract dispute. They're not as potentially, and the language doesn't kind of track with that, where they may not be as concerned with that as they might be, Fair Labor Standards Act violations, or, union disputes or things like that, failure to pay employees. That's really, so as you can see, we're kind of shifting, or at least on the adult use side, because of how the law is worded, towards actually applying what, some factors that might be critical to that, to those decisions.
Now, I think what a lot of people get confused about the criminal history question is this: am I prohibited from participating? Not always. Does that mean I don't have to talk about it? No, you will. If you're on these applications as a supplemental applicant, as an owner, as an officer, even in some cases as an employee, you oftentimes have to disclose your criminal history, whether it disqualifies you or not. So, don't, just because you are allowed to be a supplemental applicant doesn't mean you get to pretend you don't have criminal history. And sometimes if you fail to disclose that criminal history, you'll get denied. If you had disclosed it correctly, you would not have been. So that's kind of generally basically polling our office, our top 5 kind of most common questions. I'm going to add in one for fun. I can tell you the most common question I have to answer is we have a giant cannabis logo on the side of our building on Main Street here in Royal Oak, and I think at least once, sometimes twice a day, someone walks in the office and asks us if we're a dispensary. So I feel like I'm answering that question all the time. We're not. We'll point you to the nearest one. We're happy to do that. Any other common questions you get?
Other than that, Royal Oak has not opted in yet. We are not a provisioning center. We have a church too close to us that probably would prohibit that from happening. I off the top of my head, I can't. I think these are very common ones that we've been asked.
I know another one I get all the time. Where should I do this? What license should I do? Well, I'm not you.
And that's the story. What license should I apply for?
Where should I apply? What's the easiest municipality?
Kind of going towards the whole, how much does this cost? We cannot tell you how to run your business. We cannot tell you how much something's going to cost, because that's on you to figure out.
Which we can help you get there.
If we notice your projections for the initial licensure fee are too high or low, or we really think your price per pound is kind of out of whack, we might flag that for you. But really it's up to you how you want to run your business. If you want to be a edibles kitchen as a processor, or want to do the full scope of things, that's really up to you. So it's hard, because we definitely don't want to we can't advise you on business decisions necessarily, because we're not in-house counsel, we're not internally to your program. So,
or a lot of these questions aren't really legal questions. I mean, these licenses don't have to define your business. Like, there's a lot of leeway in how to be a grower when you have the Class C grower license. But just because most people are going to grow as much cannabis as they can and sell it, doesn't mean that necessarily needs to define your business model. If you're trying to do something unique or something important to the way you want to run a business, that can be reflected and likely still is going to fall under the umbrella of these license types. But if you're coming to your attorney for creativity, then you might be sorely lacking. I can make sure you don't get off track, but it's if I knew how to run the best cannabis business in Michigan, I'd likely be doing that instead. So that's a quick run through for us. Hopefully we helped kind of ping a lot of the common questions you might have. If you have a common question, or just a question in general you'd like to ask us, please feel free to reach out to us. Either comment on the video, shoot us an email, call our offices. We'd be happy to help. So thanks so much for joining us today. We'll be back a couple weeks with the next one. So for Travis Copenaver,
Nicholas Glendez,
we'll catch you next time. Thanks so much.